Good afternoon or good morning, everyone. I want to welcome you to the webinar, Top 5 Things Employers Need to Know About the Cal OSHA Emergency COVID-19 Standard. It is presented by the Temecula Valley Chamber of Commerce. Before we begin today's webinar, we have a few Zoom reminders for you to take into consideration during this meeting. The first is we encourage you to ask questions. There is a Q&A box at the bottom of your screen where you can ask a question. Our presenter will get to them either during the presentation or at the end. You will be able to see the presenter. We can't see you. So if you do have a question, it is important to put that in the Q&A box. Now, I would like to welcome our presenter. Today's presenter is an associate attorney for the law offices of Rosenstein and Associates. Her practice concentrates on estate planning, transactional matters, and employment law. She has over 10 years experience counseling employers in all aspects of the employment relationship with employees on hiring, practices, employment agreements, employee handbooks, employment separation, and wage and hour matters. As a wife and mother of 3 daughters, she strives to be an example of integrity, dedication, strong work ethic, and responsible citizenship. And these values are the heart of the service she provides to the clients at Rosenstein and Associates. Please welcome Jenny Shin.
Good morning, everyone. It's good to be with you today. I'm going to go ahead and share my screen. I have a slide presentation today. We will jump right in. All right. Let's see if I can make that large enough. Here we go. Thank you, Brooke, for that introduction. Appreciate it. Okay. Yeah, so Brooke gave my bio pretty well, and I just celebrated my 20th anniversary of becoming an attorney. I specialized in labor and employment law actually right out of law school. I did employer side law for a boutique firm in San Francisco. Then when I became a mom, I wanted to slow down a little bit and take some time. So I started my own estate planning practice in 2012. Moved to Temecula in 2014, adore being here with my husband and our 3 daughters. I have 2 one that graduated Great Oak, one that's at Great Oak, and an 8th grader at Gardner Middle. So love being here, love being part of this community. And then I joined Rosenstein and Associates in 2018 and added business transactions and other good things to my quiver of legal skills. And I enjoy being here, and I'm super excited to be able to present to you today. All right. Now, of course, a disclaimer, you can't have a legal presentation without some sort of disclaimer. So while I am an attorney, I am not your attorney unless and until we enter into a formal retention agreement. Today's presentation is for informational and educational purposes only, and nothing I say today is legal advice for you. So everyone has their own circumstances, and if you need actual legal advice, I encourage you to seek out services of a qualified attorney. All right, so let's jump in. Here is our 5 objectives for today. We're going to discuss what the Cal OSHA Emergency Standard is, what the Cal OSHA Emergency Standard isn't, how to comply with each of the technical requirements, and what employers can do now to stay ahead of the curve. And also, last but not least, what to do if Cal OSHA comes calling. So what is the Cal OSHA Emergency COVID Standard, which I call ECS? You'll see it abbreviated ETS and various things in the literature that's available. So what it is it's a legally enforceable regulation from Cal OSHA that was dropped on employers on November 19th is actually when they finalized the language. It went out for public comment on November 20th, right before Thanksgiving week. And There are regulations that require how long of a public comment period is supposed to be. And the fact that they dropped it on Thanksgiving week has drawn a lot of controversy, because basically it's seen as a way that they didn't really want to hear public comments. So the regulations took effect on November 30th. And here we are today trying to figure out, what does this mean? Because these are very significant regulations that apply to all employers in California. There's a few exceptions, which we'll talk about, that do not have to deal with the ECS, but most all employers are going to have to deal with it in some form. It will be in effect for 180 days, and it can be extended. Now, again, little to no input from employers at all. And there were many, many employer associations that were trying to get their comments in, because they were ready for that shortened notice period time. But none of their comments it didn't make any difference. So employers are not happy about that. So of course, cue the lawsuits. There's actually been one lawsuit that was filed in LA that Cal OSHA exceeded its authority, basically in two ways. One was the notice period. They're attacking that as procedurally deficient. And then the big piece that right from the get-go, everyone said, how does OSHA have authority to require pay? So basically, we'll get to that paid time requirement, but that has come under legal attack. So we'll see what happens with that. We're certainly monitoring that, and would encourage all of you, just again, with anything COVID, it's a fluid situation, just kind of keep an eye out on what's going to happen with the paid time requirement. But as of today, as we all sit here today, there is a paid time requirement if you have to exclude an employee from your workplace because of COVID. All right. So what the ECS is not, it's not a joke. Cal OSHA has already started enforcement proceedings. They're making unannounced site visits, or they're sending letters requesting proof of compliance. And these are not checkbox letters. These are letters that will basically demand to see your documentation for everything we're going to talk about today. And what's happening is then employers do their best to comply, and then a couple of months are going to pass, if it's like how Cal OSHA usually does its enforcement, and then you'll get an even more detailed follow-up. So it's not a joke. It's not something any of us should be taking lightly. So I'm going to arm you today with what you need to do to be prepared for it if OSHA comes calling, okay? So in addition to the documentation you're going to want to have, you have to have real plans that employees have been notified of and trained on, and that your supervisors need a clear understanding of the compliance requirements and how they work in real life for your workplace, okay? Now the ECS, like I said earlier, it does not apply to everyone. The exemptions from it are employers with one employee who does not have contact with other persons at the work site, employees working from home, and employees already covered by the aerosol transmission standard. And you guys know who you are. So those are the only categories that this standard does not apply to. All right, and we're going to dig deeper into these requirements for the next 40 minutes or so. Here are the main elements. There's prevention requirements, exclusion requirements, paid leave requirements, notice requirements, testing requirements, and return to work requirements. And then we'll also talk a little bit about special circumstances depending on your business. There's a couple additional things that you might have to be concerned about, but we will touch base on those as well. All right, let's jump into prevention requirements. Because again, it's Cal OSHA, occupational safety and health. So there's a piece of this where they want you to prevent any kind of COVID exposure in your workplace. Who doesn't want that? So they, in the way that the parental way they like to do, have come up with some pretty stringent requirements. All right, here's an overview, and we're going to dig into each of these. Okay, they require a written COVID prevention plan. Now, most of you, I hope, already have a site-specific COVID prevention plan, which was required by, the state of California in order to reopen earlier this year. This has some extra requirements in addition to that. And your written COVID prevention plan, which we're going to call the WCPP, It can be part of your, your IIPP, which again, Cal OSHA requires employers to have that. So you can roll it in that, or it can be a separate standalone prevention plan. There's face covering requirement. There are exemption requests to the face covering that we'll talk about. It requires employee training, physical distancing requirements, personal protective equipment requirements, and engineering and administrative controls, which again, a lot of you, I'm sure, have already, implemented the, the signage and the labeling on the floor to tell people, where to stand and which direction to go, the plexiglass barriers and things like that. That's what engineering and administrative controls talks about. You'll see my little to-dos throughout this presentation. Document everything. Every single piece of this needs to have supporting documentation, because again, that's what Cal OSHA is going to demand to see if they come calling. All right. Prevention. This is your WCPP. Employers must prepare, implement, and maintain a written COVID prevention program that includes identifying and evaluating employee exposures. You have to do an actual investigation of your work site to identify potential hazards for COVID exposure, and then implementing policies and procedures to correct unsafe or unhealthy conditions. So after that investigation, if you see issues, you have to implement policies and procedures to correct those. And also providing and ensuring workers wear face coverings to prevent exposure. So this all has to be included in this WCPP. Now, Cal OSHA has provided a sample WCPP. Of course, we would never, as employer side attorneys, say that you should, adopt it wholesale for your business, but it is there. It's a starting point. If you don't have one of these, go through it. It basically, what it's going to do, it's going to put in a policy, in a written document, all of the things we're talking about today. So it's useful in that, and if you have nothing, it's better than nothing. But I never encourage my clients to wholesale adopt anything that the government puts out as a sample. Okay, next point, the WCPP may be integrated with, and we talked about this, into an existing injury and illness prevention program. So you can just add it on as another part of your IIPP. And again, if you have that site-specific COVID plan, which I hope you do, it will need to be amended. It's not going to be enough on its own. All right, we talked about the model prevention program. All right, another piece of this is identifying, evaluating, and correcting COVID hazards, right? So this is the overarching goal of Cal OSHA when it comes to COVID-19 prevention. They want to see a process for screening employees for symptoms. Most of you, I would imagine, are doing this already, or at least were doing this. Maybe some have gotten a little bit casual in your screening procedures. I will remind you now, please take those to heart again and get back to doing what you were doing in June and July when we were coming back to work. You need a process for responding to employees with symptoms and confirmed cases. These are notice requirements. These are things that we will talk about more in depth in a few slides. You need to review existing practices for controlling COVID-19. Again, the science on this is evolving. There's been, advice that's come out from the California Department of Public Health, from the CDC, as far as, cleaning and things like that. So make sure that you have updated your procedures and your practices to make sure that they are current with the latest information. You need to identify where transmission could occur. Basically, you are going to be looking at your workplaces, and you're going to be looking for potential interactions between employees and any other people. And then places employees may congregate or interact. You physically want to go through your work site and try to pinpoint those areas and make sure that your procedures, your controls are in place, your plexiglass, your signage, your, for instance, we shut down our break room at our offices because that was a small room where people would congregate, or where they would pass each other and they had to be within 6 feet of each other. So we just closed that down to eliminate that. Now, this is not going to be triggered by employees passing each other in a hall or passing each other on a staircase. that would not be considered a violation. We're talking about places, static places where people are in close proximity to each other, you know, for more than just moving past one another. And then you're going to need to, oops, I went ahead too fast. There we go. You're going to need to implement procedures to correct identified issues and document that. They're going to want to see this actual investigation, analysis, you know, where you've identified issues and how you've corrected them. Okay. The face covering requirement under the ECS, you're going to need to, employers have to provide employees face coverings or reimburse them the cost of face coverings. Employees can provide their own, because I know we've been in this long enough now where people have preferences as to what they prefer. So if an employee wants to provide their own, that's fine. You need to reimburse the employee the cost of that. You're going to ensure coverings are worn over the nose and mouth. That is your obligation. Basically, OSHA has put you in the seat of having to enforce that. And so political opinions aside and everything else, your obligation under the standard is to ensure that coverings are worn over the nose and mouth when indoors, when outdoors, and closer than 6 feet to each other. So it's inside and outside if they can't be more than 6 feet apart. Okay, and you're going to need to enforce your policy. It's not just here, look, we have this policy, we can check that box. It's going to need to be enforced. So you need to put some teeth behind it. If you have employees that are refusing to comply, then you need to write up those employees and document that. That's just, it's not worth you risking your exposure you're going to face to a Cal OSHA action for employees to mess around with this. It just has to be enforced, okay? And you cannot substitute COVID testing for the face mask requirement. You can't just say, oh, well, we test our employees once a week. We don't need face masks. Nope, can't do that. All right. Now, there are some exceptions. Here they are for the face mask requirement. If your employee is alone in a room, so if you have separate office spaces for your employees where they're more than 6 feet from the next office, they don't have to keep their face covering on when they are in their own office, for instance. So if they're alone in a room, no face covering is required. When they're eating or drinking, again, don't do what the Disney folks have done and just walk around with a water bottle thinking that that excludes you from wearing your face mask. It doesn't. You have to actively be eating or drinking, like while on a break. If you are in an industry that your employees have to wear respirators or respiratory protection, you know, paint, I don't know all of them, but if your employees regularly wear respirators, they don't have to wear face coverings too. If you have hearing impaired employees or employees who communicate with a hearing impaired person, they are exempt from the face covering as well. And then when specific work tasks cannot be performed with a face covering. And I was trying to be creative and come up with some, and the only thing I could come up with was glass blowing. So you would know in your workplace if the specific work tasks would make wearing a face covering not possible. So here are the exceptions. There's a huge caveat though, because even if you grant an employee an exemption, down here, 4th bullet point, it must be possible for the exempted employee to be 6 feet apart from other people. So if you have employees that, yes, they meet the exemption, we documented it, they still have to be 6 feet apart from other people at all times, or they must be tested twice per week at your request and at your expense. Okay, so exemptions aren't just going to be something that's going to be thrown around, you know, like confetti. All right. So you need a documented procedure for requesting the exemption. You need to communicate that to all of your employees. And if an employee requests an exemption for health reasons, this is something that could trigger an ADA issue. So you have to engage in that interactive process to find a reasonable accommodation. And a reasonable accommodation in the COVID era can be all kinds of things. It can be letting them work from home. It can be, if you have the sufficient, you know, square footage, setting them off by themselves in an office away from everybody. It can be a bunch of different things. So if you get a request, you know, you need to go through and go through that analysis with your employee and bring in specialists, you know, and advisors outside if you need extra guidance on that. Okay. All right. Employee training. Okay, this piece is big. You have to communicate prevention procedures to all employees. So when you come up with that WCPP, you need to make sure all of your employees get a copy, have them sign an acknowledgement form, put it in their personnel file. Make sure that they actually have a training where they know what these procedures are. They know the face covering requirements. They know the physical distancing requirements. They know how to prevent COVID to the best that they can. You know, we went through this training early on in June and July when we came back to work. It's that, but again, you want to make sure you include these additional requirements under your WCPP. Okay. How it's spread, infection prevention techniques, how to report COVID-related information to the employer without fear of reprisal. Okay. We're going to be jumping into these notice requirements in a second, and what happens if you have an employee that is COVID positive or who's been exposed to a COVID positive person. We need them to be comfortable reporting that, and they're not going to get in trouble, and they're not going, you know, you cannot have reprisals against employees for reporting that to you. And so this is not a don't ask, don't tell situation. Okay. You need to inform your employees and train them on how to obtain testing. We're going to talk about that. You need to develop a relationship with a testing facility now and actually be able to communicate that information to your employees, or if it's through their health plan, or if it's through the county. You know, there's different avenues we can go to get a COVID test. You need to communicate that to your employees. And it's not just, here's a list of available testing sites. It's, here's somebody I have a relationship with, because you, employer, have to pay for that test. So it's more than just giving them a printout of, you know, close by testing facilities. Okay. And then you have to provide them information regarding COVID-19 related benefits that affected employees may be entitled to. This is paid leave, continued seniority, continued health benefits. You need to actually give them notice of that. And I have on here to do written training materials and proof of completion. You're going to want to track when your employees are trained, and you're going to want to, you know, write down the date, write down who all was there, and keep track of that with the rest of your, you know, your ECS documentation. Okay. Physical distancing requirements, I touched on these earlier. You need at least 6 feet between persons, unless it is impossible. And then they need to be as far from others as possible. And again, I said less than 6 feet while in movement is not a violation. That's the stairway or the hallway. Now, if you're claiming impossibility, you have to be prepared to show Cal OSHA why physical distancing is not possible. You actually need to physically lay out the case why they can't be, you know, more than 6 feet apart. Methods of physical distancing. We talked about it a little bit. You're going to offer teleworking or remote work arrangements if that's available to your workforce and it makes sense for your business. You're going to reduce the number of people in an area at one time by staggered shifts or staggered tasks. There needs to be visual cues like signs, floor markings, you know, telling people which way to walk through doors. You've seen them in the stores. I'm sure most of you have this already going on in your work site. We talked about staggered arrival, departure, work, and break times, just to reduce the possibility that there's going to be traffic jams with people. And then adjusted work processes or procedures to allow greater distance between employees. This is a very workplace specific analysis, but the standard is pretty high. You're going to have to really make the case for why you cannot honor the 6 foot physical distancing. Okay. Talk about PPE. You need to evaluate the employee's need for PPE for your workplace. Some people need gloves, eye protection, and respiratory protection. Some don't need any of that, just a face mask will do. So that depends on your workplace. You need to provide PPE at no cost to the employees, or you need to reimburse them the cost if they buy their own. You need to prohibit the sharing of PPE. That just needs to be on a sign in your policies. And you need to ensure an ample supply and regular restocking of PPE. One of the things that we're hearing is that the Cal OSHA wants to see that you have a history of receipts of the PPE that you've bought, or that you have recurring orders placed for PPE, things like that. So keep that in mind. Basically, what Cal OSHA is getting ready to say is, you should have had this in place already, so when stocks run low, it's no excuse saying you can't get that PPE. So was a little startling. All right, and we talked about engineering and administrative controls. Again, this is the plexiglass. This is the, now they're saying maximize amount of outside air when conditions permit, open your windows, provide ventilation, use fans, to maximize the amount of outside air that comes in and refreshes a workplace. So that's something new. Cleaning procedures of commonly touched surfaces, that's nothing new. And yeah, on the right, minimizing sharing of tools, things like that. Deep cleaning affected areas, that's a little bit more stringent now with the ECS. And we can talk more about that as well. And then, again, hand washing, hand sanitizer, by now we're all pros at that. All right, so you've done your best to prevent it, but what are you required to do upon learning of a COVID-19 exposure in your workplace? All right, so what is a COVID-19 case? We're gonna talk about COVID-19 cases and COVID-19 exposures. Okay, COVID-19 case is an employee who tested positive for COVID-19 who was ordered to isolate by a public health official. And these employees have to be excluded until they satisfy ECS's return to work requirements. Now, this is in contrast to an exposure. This is an employee who was exposed to a COVID-19 case, basically an employee within 6 feet of a COVID-19 case for a cumulative total of 15 minutes. Notice that word cumulative. That doesn't mean that they were there for 15 minutes. It means throughout the day, they had more than 15 minutes of exposure to this person within any 24-hour period during the high-risk exposure period. Okay, and this high-risk exposure period, again, these are very technical requirements. Here's how it's laid out, and it depends on whether it was a symptomatic or an asymptomatic case. Because again, there are cases where people showed no symptoms. But if there were a symptomatic COVID-19 case, then basically what you're looking for that high-risk exposure period is you're going 2 days before until 10 days after the onset of symptoms. So you have to get this information from your employee. You have to find out, when did you first feel symptoms? You count 2 days before, 10 days after. That's the window. It's a big window. But also they have to be fever-free for 24 hours without use of fever reducers. So it's 2 days before, 10 days after onset of symptoms, and they're fever-free. So that's for symptomatic COVID cases. Asymptomatic, so they're not showing any symptoms. The window is 2 days. So now you're going to look at the day that their specimen was collected for their test, not the day their results came out, because some results take 5 days. So you go back to the day that the specimen was collected. You count 2 days before and then 10 days after. That is your high-risk exposure period. You have to figure out which employees would have been potentially exposed, and then you have to give notice to all of them. And what's going to happen with these guys, your COVID case and your COVID exposure, is they have to be excluded for 14/10 days from last known exposure. Now, the reason that 10 is in parentheses is Governor Newsom actually did an executive order that helps employers a little bit. He basically came back because after this, ECS came out, there was the California Department of Public Health came out and said, actually, a 10-day quarantine period is okay. So then Governor Newsom, he did executive order that basically says, specifically addressing the Cal OSHA ECS, and says that any applicable, quarantine or isolation period recommended by the CDPH will replace this standard. And so right now the CDPH recommends 10 days. So that's what you go by. And this was brand new. This just came out on Monday. So we are still processing that, but in any event. All right. So again, COVID-19 case, employee must be excluded from the workplace until they meet the return to work requirements. And then your COVID-19 exposure, everyone who is exposed to that COVID-19 case, those employees have to be excluded from the workplace for 10 days. Or they can be temporarily reassigned to work where they do not have contact with another person. Again, depending on the nature of your facility, if you can swing that, that would at least allow this employee to stay in the workplace versus having to go home. All right. Now the kicker here, this is not limited to one occurrence and it's not capped. So if you have an employee that keeps getting exposed, that's going to be, that's going to be a really, really heavy burden, because the Cal OSHA standard does not limit the exclusion requirement to one occurrence, and it doesn't cap how many times, how many days the employee has to be excluded. All right. Employers must maintain a record and track all COVID cases in their workplace. I'm sure most of you, your alarm bells are going off when you think about that because you're thinking about private information, and rightfully so. We'll talk about that in a minute. And here it says, so yep, you have to maintain a record while ensuring medical information remains confidential. So how you track that information is going to be very important. Now the records have to be made available to employees and their authorized representatives with all personal identifying information removed. So if you have an employee that requests information about the COVID cases in your workplace, you have to provide that information, but you redact all of the personal identifying information from it. Now, if you have an outbreak or a major outbreak, and those are defined terms, which we'll get to in just a minute, the records have to be given to your local health department with that information included. So you don't redact it from the records you're providing to the local health department. This helps with contact tracing and also with their, just trying to manage this, the pandemic. So they need that information, and that would not be any kind of violation of any kind of HIPAA or anything like that when you're producing that information to your local health department. All right, and I know these are all potential landmines. It just makes the hair on the back of my neck stand straight up. Okay. Again, it's matter of degrees of magnitude. We talked if you have one case, regardless of where they caught it, you have to exclude that person. Okay, so one case, regardless of the source, that employee has to be excluded from your workplace until they meet the return to work requirements. Okay, multiple cases. This is considered, I like to say multiple cases, they call it an outbreak, but to me that gets too confusing with major outbreak. So anyway, I just think of it as multiple cases. Is 3 or more COVID-19 cases in an exposed workplace in 14 days. So you have employee 0, your one case comes in, and then after that you have basically 2 more for a total of 3 within a 14-day window. And if that's the case, then you have, this triggers additional notice and testing requirements, including contacting your local health department within 48 hours and things like that. And I list them in subsequent slides here. Or if you've been identified by local health authorities as a multiple case employer, then you'll know that because they will notify you and they'll tell you exactly what you need to do. All right, and then a major outbreak, worst case scenario, is 20 or more COVID-19 cases in a 30-day period. That's a major outbreak, and there are even more notice and testing requirements, also physical facility requirements, ventilation changes, filtration. That will be something that will essentially, that's the one that you're seeing in the headlines about that Cal OSHA is trying to shut down employers. It's when they talk about that major outbreak. Okay. All right, paid leave requirement, thing that keeps us all up at night. Okay, any employee excluded from work because of work-related exposure must continue to be paid their earnings during the exclusion period. Now what is earnings? That's not defined in the regulation, but a good rule of thumb, because it applies in context of other regulations, is you look at their 90-day average earnings. If it's a non-salaried person, you look at the last 90 days, come up with the average, that's what they need to be paid while they're being excluded. They also have to keep their seniority and benefits, and they have to be provided information about these benefit entitlements. So if you come up where you have to exclude an employee from your workplace, you have to give them notice that they're eligible for paid leave and to keep their seniority and benefits. Okay, so that's something that I have on here to do, to have these templates ready to go, these notice to excluded employees, notice to local health department, notice to all employees requiring testing. There's a bunch of notices that are part of this. And one of the things that I strongly encourage my clients is that you have these templates ready to go, because the turnaround time is extremely fast. Basically, if you have an employee that is a COVID-19 case and you have to give notice to people that they were could have been exposed to that employee, you have to do it the same business day. And then again, if you have 3 or more cases, you only have 48 hours to notify your local health department. So you want those notices kind of ready to go where you can just fill in the specifics. Okay, now people are asking, is this in addition to the FCRA or the CCA paid leave, which is supposed to expire at the end of this year? We'll see if it does or if it's going to be extended. If the employee caught COVID in the workplace, then the paid COVID leave under this emergency standard is in addition to the FCRA or the CCA paid leave. Okay. Yes, it's as bad as it sounds. Now, there is a legal challenge, as I mentioned earlier, challenging the authority of that, of the Cal OSHA's authority to require paid leave, because they're not mandated. They don't have authority to set wages. So this is something to me that should be stricken down in the court, but that just takes time. All right. Now, if an employee is hospitalized, they still get paid unless the employer can show that the employee wouldn't be working anyway. So if your employee doesn't work weekends, they're hospitalized over the weekends, you don't have to pay them for that time. Okay. Or if the employer can show that the exposure was not work related. Now, this is tricky. You can probably show that on the very first case because they are the one that brought it into the workplace. But after that, it's pretty much going to be a presumption that they caught it in the workplace. You know, if they were in the same vicinity as that employee, you know, during that high risk exposure window. So that's, don't put much hope into the showing that it wasn't work related, unfortunately. Okay, notice requirements. So here I mentioned earlier, one case, then you have to give notice the same business day, and you have to give that notice to all of your employees, their exclusive reps. So if you have a, you know, a union shop, you have to give it to their union reps, independent contractors, and employers of subs who were on the same premises as the COVID case. Again, don't divulge confidential personal identifying information. And in that sample WCPP that Cal OSHA has provided, they actually have some in the appendix. They have kind of some forms that you can use internally to track this information. And I like how it's set up because it kind of is set up in a way that it doesn't give any personally identifying information. And then you basically attach supporting documentation that you could then redact pretty easily. So look at that sample, if for nothing else, in the appendixes. Okay, so again, I mentioned it, notice templates for each type of recipient. You also, if you're going to give notice, if you're going to need to test employees, which we'll get to in just a sec, you need to explain the reason for the test and also the possible consequences of a positive test, which are what? Possible consequences are exclusion, but paid. So you need to give notice to your employees of that. All right, we talked about the additional notice requirements, the more cases that you have. So 3 or more cases, it's an outbreak. So in addition to column 1, you must give written notice to the local health department within 48 hours. And then that notice has to include the confidential information. I bolded it down below. In the horrific situation, if you have an employee who passes away from COVID or who is hospitalized for serious illness that's COVID related, then you have to immediately report that to Cal OSHA directly. So the to-do I have here is to gather and post contact information for local health department and Cal OSHA. Make sure your supervisors, your managers, everyone's got, you know, you've got that information on hand. The local health department notice, here's the elements. You need to include the employee's name, occupation, work site, business address, the NAICS code, and I list there the website where you can find your NAICS codes, the total number of cases in your work site, and then if it's hospitalization and or fatality status, which I mentioned. Plus, there is an ongoing notice duty if you have additional cases that roll in, because again, this is triggered at 3 cases. So as those additional cases roll in, if they do, then you have to update your notice to the local health department. Okay, testing requirements. Okay, if you have one case, again, regardless of source, you have an employee that comes to you and says, I have a positive COVID test. Okay, the employer has to offer for all employees potentially exposed to that COVID case. For every single one of those employees, you have to offer free COVID testing during work hours. So you have to pay for the testing and they have to be able to take the test during work hours. If for some reason, you know, the timing of it is, no, it's a Friday and they're going to go over the weekend, you know, you have to pay them for that time. So that's how that's going to work. You have to inform all employees on how they can obtain testing. Again, the onus is on the employer to come up with a relationship with a testing facility and to communicate that information. Okay, multiple cases, 3 or more cases in 14 days. So in addition to that first column, you have to offer potentially exposed employees immediate testing. They have to go right then and there. and then a follow-up test 1 week later. So it's not just a one and done, it's follow-up test 1 week later. Then you have to offer continuing testing on a weekly basis to employees who remain in the workplace until the worksite is out of a multiple case scenario. So an immediate test, a follow-up test 1 week later, and then continuing testing if that employee is staying in the worksite. And again, these are obviously, they test negative and they're not excluded, they're still working. So this is to protect those employees that are, working in these multiple case scenarios. Okay. Major outbreak, if you have 20 or more in that 30 days, it's the same. Free testing immediately during work hours for all. This is for all employees. Doesn't matter if they were potentially exposed. At that point, if you have a major outbreak, all of your employees have to get tested. Your ongoing testing requirement is twice a week or more frequently for employees who stay in the workplace over a 30-day period. So again, worst case scenario, you don't want to be shut down. You're doing your best to stay open. Your testing requirement is just going to increase twice a week or more frequently for employees who stay in the workplace. Okay, and that obligation lasts for 30 days. All right, now again, you have excluded employees. When can they come back to work? There's 3 boxes you have to check. Basically, your excluded employee has to be fever-free for at least 24 hours without using any fever-reducing meds. And a fever is defined as 100.4 degrees. And so you have to check all 3 boxes. Number 2, that their symptoms have improved if they were symptomatic. Now, if they were asymptomatic with a positive test, then they have to wait at least 10 days from the specimen collection date. And you can ignore that 7 days from a negative test because that's not going to actually help us. Okay. And then the 3rd box is a 10-day window. At least 10 days have passed since symptoms first appeared. So fever-free for at least 24 hours without taking anything to reduce their fever. Symptoms have improved, or if they're asymptomatic, at least 10 days. And at least 10 days have passed since the symptoms first appeared if they're symptomatic. Okay. So your to-do here is develop a written protocol for gathering this information and keeping it confidential. If you are a work site that is subject to the Consumer Protection Act, get waivers from your employees if you're going to be saving this information, their temperatures and things like that, because this would trigger CCPA. And so you know who you are, get waivers. Okay. Now, a negative test is not required. And employers actually cannot require a negative test. You cannot require a negative test for your employees to return to work. And you can't require a test at all as a condition for employees to return to work. The only requirements are the ones that were laid out above in the ECS. It's those 3 requirements. That's it. You cannot require a negative test. Your mantra in all of this, when it comes to return to work requirements, you want to communicate with your excluded employees. You want to document everything. You need to protect their personal information. Communicate, document, protect, okay? We talked about outbreaks and major outbreaks, that's the worst case scenario. We talked about the additional reporting requirements. And then also what you have to do, you have to conduct an investigation, a documented investigation. There are specific requirements involved. Again, that sample WCPP actually has some forms in the appendix. It's a spreadsheet basically of what the steps you take in an investigation. So you can start there when developing your own prevention plan. So you have to conduct an investigation, perform a hazard assessment, and take corrective action and document everything. These are going to be the situations where Cal OSHA is going to come in, like, I don't know if you've seen Monsters, Inc., but when they have that 2319 and those little yellow guys come down from the ceiling, that's kind of the picture I see in my mind, trying to lighten this a little bit. I know it's a very serious situation, but with these outbreaks and a major outbreak especially, they're going to be demanding strict compliance with these requirements, okay? And these outbreak requirements apply until there are no new COVID-19 cases detected in the workplace for a 14-day period. So you have to have no new cases for a 14-day period. Otherwise, you have these additional testing, these additional reporting, all those requirements are just ongoing. Now, again, I talked about that we'd have some specific situations. If you are an employer that provides housing to your workers, I know here during harvest time, we have some employers that when they bring in their extra workers, they provide housing and transportation. There are extra requirements and I lay them out here. And basically they come up under, you know, I would just say contact a specialist because they're even more stringent. And I don't want to take the time really to go through them here because I don't know that it applies, especially because we're not close to harvest time now. But if that is you, you can call me after this and I can go through this with you just to make sure that you've got the basic information and would know what to do next, okay? But basically it's additional space, additional cleaning, additional isolation requirements. They basically have to have their own self-sufficient isolation space and it's intense. And then employer-provided transportation, same kind of idea. You screen employees before they board. They have to sit at least 3 feet apart. They have to wear a mask the whole time. And then you have to disinfect the interior and shared exteriors every day. So if you provide your employees transportation, these are your requirements. I talked earlier about the executive orders. We're going to keep an eye on Governor Newsom to see what he does, other than probably extend the stay home order. We'll see what else he does in response to these OSHA requirements, if anything. And we talked about that. So the effect of his executive order N8420 was that there's a 10-day exclusion period rather than a 14-day. All right. Here's your plan, what I want you to do today. Okay. Your written COVID prevention plan and your notice templates. You need to task somebody with getting those together. I want you to lock in your test providers. You need to come up with your list of people you've spoken with and made arrangements with because you have to pay for those tests. Your employee training materials, again, that sample WCPP has some materials in it if you need a place to start. Your face covering and physical distancing requirements need to be implemented immediately. Your procedure for employees requesting an exemption from those requirements. Your PPE evaluation, make sure that you guys are restocking on all your PPE. Your cleaning and disinfecting protocols, review them, make sure that they're still being honored. Make sure you have supplies to do that. Your procedure to investigate and respond to COVID cases in the workplace. So get your checklists ready, get your, your clipboards out there and get your people trained to know how to respond when you get the inevitable COVID case in your workplace. Now, if Cal OSHA comes calling, what they're doing, I mentioned earlier, an unannounced on-site visit or a letter requesting required documentation, they will ask about all of the things on the previous slides. So you need to be prepared to show and provide that information. And make sure your frontline managers are thoroughly familiar with all of the COVID-related policies, procedures, and your materials, like a working knowledge, not just, oh yeah, we have one of those somewhere. They need a working knowledge. And then you also need to make sure your employees have been trained well enough that they know how it works, because the Cal OSHA inspectors will be asking your rank and file employees also about the procedures. So the training piece of this is very real and something that you have an obligation to take very seriously. Okay. All right, so that's all the meat, and it was a lot of meat. So we're gonna open this up. I see in the Q&A there are some questions. Can you request copies of employees' tests? Yes, you can. You can, but if you take them, you need to make sure that you're protecting the confidentiality of that information. So if, for instance, you just want to see it and hand it right back to the employee, that's what I would do. If you want to take a copy of it, then you're going to need to really make sure that that's protected information. It's just not worth risking that. I just recommend that you have somebody look at the test and give it right back to the employee. Don't keep a copy. If you do end up having a copy and you shred it, have a documentation that you shredded it, date that it was shredded, who did it, have them initial it. So that's that answer. Can you request positive test copies? Oh yeah, yes, that's kind of the same question. I think that's the same, Wendy. Let me know if that's not. What are the ramifications of keeping our front office door locked to keep people from just walking in? The ramifications of keeping our front office door locked. I would put just sign on the door. Maybe I might need more information on that one, Wendy, but the ramifications, you can, a lot of employers, a lot of business places, especially offices, are restricting access to their buildings because you need to screen people that are coming on into your site. So I believe that the ramifications would just be, I would post a sign on the door, you know, if you have a doorbell or if you have somebody that they need to call a number to notify you that they're there. And I would just also list that you will be screening and what you'll be doing. Post that on your door and see what happens. I hope that I answered that question. Deb, what if you're a nonprofit and your employees are all volunteers and one of them gets COVID while in the field? Are you still responsible for paying for the testing? I'm glad everyone works from home, because that to me is the best case scenario, because then the ECS does not apply to those employees who work from home. If you have an employee that is on site sometimes and not the rest of the time, the standard applies while they're on the work site. Now here, that employee or that volunteer, and again, volunteers would still count as workers under the law, so this would apply to your volunteers, gets COVID while in the field. So that's an employment related COVID case. So they'll be excluded and you will need to pay. But I don't know if you pay your volunteers. But if you don't pay, if they're unpaid volunteers, you would still maintain their, if you give them benefits or seniority or whatever they're working towards, that would still need to be maintained without interruption. So I hope that answered your question. Oh, unpaid, there you are. So yeah, so if, you know, if they have seniority status or anything like that, that while they're excluded from working, that all has to be maintained. Does that answer your question, Deb? Okay, and if not, call me after, and maybe if I have a little bit more info, I can give you a little bit more detail. We have a sign. People think we're tied in with Frontier. Oh yeah, just walk in. Oh man, by law. Oh, by law, I see what you're saying. I think in this situation, safety trumps that. So if the reason that you have to keep your doors unlocked is for a fire code or something like that, maybe contact your local inspector and find out what they're saying to do, because here, this is safety just to me as important as fire code laws. So again, lots of us have our doors locked right now. So because you have to control who comes in and who goes out, and you have to control the flow of traffic through that door. So, and it's probably not practical to have an employee that's posted there and waiting for people. So again, signage, documentation, those are going to be the things that you'll be required to provide. All right. Okay, I don't see any other open questions. We've got a few more minutes though. If anyone's got any, throw them at me.
Well, I will be following up with an email, and I will have your contact information in there to everyone who registered, so they can reach out if they have questions.
Perfect.
Wonderful. Thank you, Jenny. We appreciate your time and all of this information. It's so important.
It is important. And Wendy, I'm with you. It is very scary. It really is. I sympathize with all of my business owners. You know, you guys already have been trying to just do what's right for your employees all along, and you know, still try to keep your doors open and doing everything you can. And I applaud you for that. And I'm rooting for everybody. Do the best that you can with this. Just document everything. That's what's going to save you here. Is there a good place to find templates? You know, I went online to try to see if maybe the insurance companies were providing anything yet. I didn't see anything. There's, I know that there's law firms that are providing, you know, packages and things like that, but it's all paid. As far as finding free things, I've not seen anything. I know there's a law firm, Fisher Phillips. They've got a compliance package that they rolled out the first day this came out. So they were definitely ahead of everybody on that. I don't know the price of that or anything, but you know, our firm of course can help you with notices and things if you have questions. You've got my email, you've got my phone number. I'm very nervous as a nonprofit owner. I know, with all volunteer staff. I understand that entirely. Yeah, small business owners right now in general are very concerned. Although the stimulus package supposedly has some pretty good relief steps in there for small businesses, I did want to say, I believe Robert Rosenstein of our office is going to be putting together a flash update on the new stimulus. He's talking about doing that next week. So my email's up there. If you email info at the Temecula law firm, if you are interested in something like that, we're going to be putting together materials. That just came down yesterday. You know, the part that we need to look at is 5,900 pages long. So we're going through it, but he is going to put together a flash update on that next week. All right.
All right. Well, thank you so much, Jenny. We appreciate your time and all the information, and I will be following up with everyone. And
Okay.
you have a wonderful holiday, and we're going to look forward to Robert's flash update as well with all of his information.
I hope it's got some good news for you guys. All right. Merry Christmas. Happy New Year, everyone. And thank you, Brooke.
Thank you. Bye-bye.
All right. Talk to you later.